to move to the DPP, etc., until it gets to you.
Can
we go back to the point of where you said it gets to the DPP and then he reviews, etc.?
Yes.
Further, before we continue, at some point I would request that you be looking at me more because we're communicating instead of the commissioners.
Yes.
So that way in that aspect we don't talk over each other.
Yes.
Thank you. You may continue.
Sorry, I didn't hear you.
You may continue.
Oh,
I wanted you to go back to where you talked about the file being at the DPP and then moving over before it gets to you.
No, I think I was done with that. I said usually it would come to me once they completed their opinion, and the DPP would annotate on the opinion sheet that was presented by the council who prepared the opinion, and then he would minute to SG, and then SG would review it and then send to me. So usually, I think the point I was trying to raise is that if I did not agree with the opinion of the DPP or the opinion that was presented, and then the SG, sorry.
mu ngi wax rek ne comme fi mu jaaroon rek ci file bi fi mooy jaar ba balaa moo agsi si moom mu ne li mu fi bëgg a wéral rek moo nekk ne bu fekkee ne moom am na loo xam ne nii féewaloo na ci ay xelaatam ak ñi nga xam ne nii ci ñoom la file boobu jaaroon bokk na ci di DPP bi.
Yeah, the role of the DPP would now to convince us to why there's a need to prosecute or not to prosecute.
Li wàlli DPP bi nag mooy pour mu wax ñu nag li nga xam ne nii mooy dalal suñ xel ne lii dafa war a nekk lu ñu war a àtte wala du lu ñu war a àtte.
Given my oversight role, I just need to make sure that he knows he has the requisite evidence to prosecute that case because he would take responsibility for it.
li nga xam ne ni nag moo nekk suma wàll yi tamit ci loo xam ne nii jéggale naa ko rek bokk na ci di pour moom it mu xam mu nekk koo xam ne nii màcc na nag ci li muy wax ndax boobaa nag moom mooy gàddu it ci gannaaw boo xamee ne nii am na firnde yu wér pour mun a àtte.
And what I had also concluded in saying is that no matter what happened before a case is prosecuted,
tey tamit fi ma sottale woon rek mooy ak lu munti xew balaa ñuy àtte benn layoo.
The law and the facts there has to be reasonable case for that prosecution of that case.
Loi bi ak case bi foog si mu nekk nag loo xam ne nii lu wér la ci ni nga xam ne mu ngi jëm si ni ñuy àtte case boobu.
Yes.
Thank you.
Jërëjëf.
If I may take you back a bit. In your statement, in your testimony, you stated that from the DPP, the file goes to the Solicitor General. Is that correct? Is that a procedure that's created by law?
No, because when I assumed office, the procedure was automatically once he's completed his opinion, he will come straight to me to my office to approve or not to approve.
Déedéet waaye nag man bi nga xamee ne na falu naa ci maqaama boobu balaa loolu nag dafay war a ñëw ci man du jaar fen pour nag ma ànd ci wala déet.
At that point, I'll write to refer you to the Constitution. If you may look at section 85.4. And if you could read it out, please.
In the exercise of his or her function under this section, the Director of Public Prosecution shall be subject to the direction and control of the Attorney General.
mooy bu fekkee tamit nag ki nga xam ne mooy doxalin bi ki nga xam ne nii mooy Attorney General bi saytu na nag lii tëddalin ak doxalini direct public prosecution.
Yes.
Your mic, Council. Yeah.
Section 85.4 of the Constitution states that the Director of Public Prosecution shall have, in the exercise of his or her function under this section, the Director of Public Prosecution shall be subject to direction or control of the Attorney General.
Yes.
Director of Prosecution bi mom dafa dox ci li nga xamne modi ndigalé Attorney General.
I think then that means that the procedure you met at the Attorney General's chambers when you assumed office was correct.
Wan nak li nga xamne mom nga fa fekkon ba nga nek Attorney General bon li dox na baax na jaar na yoon.
Meaning
yes,
that
it's the law. It's the law, but I had a policy in place. It's my office, so I create policies as well.
loolu mooy loi bi waaye nag comme que suma office la am naa yelle fi doxal suma ay sarta.
I'm sorry to say, but policies cannot override law. So maybe you should have maintained.
Actually, again,
the procedure.
Sorry.
May we not talk over each other.
Sorry.
Maybe you should have maintained the procedure that you met there, because that is what the law stipulated.
I disagree, because even though we have laws in place, but you also have procedures and policies that guide you in the implementation of that law. So yes.
Anduma ci de ndax naam sax am nañ ay loi waaye nag am nañ ay sarta ak tëddalin yoo xam ne nii ñoo laay teetee nag ci loi boobu noo koy àggalee.
So I put in place that policy just for the Solicitor General to serve as a check for me.
Man nag maa tëddal nag sarta boobu noonu tëddalin boobu rek pour Solicitor General bi moom it mu may ci seetaaleel mbir yooyu.
Because two heads are better than one.
Ndax nag lu ñaari xalaat seq moo gën bu benn seq.
Ms. Singhateh, I believe earlier on in your testimony, you already explained the capacity, the quality, the experience that the DPP needs to have.
I did.
And I think further, the Constitution also stipulate the experience, the capacity, the quality that the Attorney General needs to obtain to hold that position.
Constitution bi wone nañ tamit Attorney General momi tamit li nga xamne modi matcha bu mu wara am ci wali ligeyam ak mun bi nga xamne ci la wara sukkandiku.
So therefore I'm sure that's why the law provided that the two heads, which is the Attorney General and the DPP, should be enough to make a decision.
Amna lolu motax nak lu wa bi dal di teural ne Attorney General ak DPP bi ñaari xelaat yoy rek doyna pour ñu def dogal.
There's nothing wrong to adding a third head as well, just to be doubly sure or triply sure.
Amuna dara lo xamne ni sik na ci pour nak bolé wacc ñetteli nit ki pour mu gëna wër rek.
Well, if it violates the law, it is a problem, because policy cannot override law.
It does not violate the law, because the law does not prohibit the Attorney General from consulting his or her advisor, and the Solicitor General is the advisor to the Attorney General.
Tout ben loi ndax amul ben loi bo xamne ni tere na ki di Attorney General di dekku ay xalaat yo xamne mu ngi joge ko ci ki nga xamne mokoy yedd te itamit nak Solicitor General bi moy ki ko lay yedd.
Ms. Singhateh, I wish to differ on that point, because the law is clear, so we should have just talked to what the law said.
Ms. Singhateh ñu jall fofu parce que loi la rek te dañ wara sukkandiku wëru ci nga xamne mom la loi bi wax.
I disagree.
Lool anduma ci.
I would leave it to the Commission to draw conclusions on that issue. I would like us to move to the next point, which is talk about the interference of investigations and prosecutions by the former president. By issuing executive directives. We have several communications here that show that letters emanated from the Office of the President to your office. Is it correct to say before this commission that that was a trend?
What trend are you talking about?
Executive directives being sent to your office for implementation.
Yes, the executive is vested with executive powers. So yes, we do receive executive directives.
Wow, danañ dé jot ay ndigal yu joge ko ci président ndax mom itamé rango na doole bo xamné ni mën na joxe ndigal ñu dékku ko.
Does he also have the power to sack magistrates and judges?
Ndax mom itamé président amon na doole pour dax ay magistrate ak ay judge ay attekat.
Yes, he did.
Wow.
Only when they did judgments that he wasn't happy with, that were not in his favor.
That is not within my knowledge.
If I may show you this letter, which is dated the 6th of November 2015, and it is from the Office of the President by the Secretary General. It is headed extremely urgent. And the subject matter is court dismissal for lack of jurisdiction at Brikama Magistrate Court. Does it ring any bell?
No.
Mr. Chair, with your permission, I'd like to show the witness the letter.
Thank you. Okay.
Is it correct to say that this is an executive directive from the Office of the President, directed to your office?
Yes, it was a letter from the Office of the President sent to my office.
Wow, letter la bo xam joge ko ci office president bi ñu ebal ko ci suma office.
And it is correct that in this letter there was a directive to dismiss a magistrate because the executive were not happy with the decision he made. And this letter was during the time when you were minister. I just thought I'd bring it to your attention to show that executive directives did come from the Office of the President. I have another letter dated the 24th of March 2015. And it is to do with a particular case where the executive wanted charges to be pressed. Can I show you the letter?
Yes, please.
With your permission, Mr. Chair. And with permission, Mr. Chair, I would like the witness to read out the letter.
Should I? Okay, this is a letter that is dated on the 24th of March, addressed to the Attorney General.
Li nak letter la bo xamne ñu ko bind ñaar fukki fan ak ñent ci wéru March mu jëm ci Attorney General di ki seytu wali atté bi fi ci réew mi.
And it is signed by the Secretary General.
Ki ko signé nak moy Secretary General.
And it reads,
letter bi nak li lañ ca bind.
I invite reference to your letter.
Ma ngi oté nak li nga xamne mu ngi jëm ci letter bi ngeen jitalon.
Reference number indicated.
Reference number bi ñu bind ko.
Of March 10th, 2015.
Lu jëm fukki fan ci wéru March atum 2015.
On the above and hereby convey executive directive.
Té tamé nak di agalé ndigal bo xamné mu ngi joggé ko ci président bi.
To the effect that your office should rectify the error in respect of the charges against one Mr. Desimone Sandro.
Ne sen office war nañu défarat njumté bo xamné ni amna ci tuuma yi nga xamné mom lañ tek ci turi kam tuddu nonu.
And should be tried again under the appropriate charges.
Té bu ko défé ñu atté wat ko ci kaw tuuma yi nga xamné ni mo war.
Yes. And it was minuted to DPP. Please work on this directive urgently, signed Solicitor General 23rd March 2015.
Té tamé nak Solicitor General bi momit dal dina ci bind dara wax won DPP bi ne ko gaawal ci li nak nga xamné ni moy liñ wax ni.
Yes.
The said letter was addressed to your good self.
Letter bi yow sa bop lañ ko yónnee won.
It was addressed to my office.
Office bi lañ ko yónnee mu ne.
It was addressed to the Attorney General and Minister of Justice.
Yes, my office.
It did not say the Attorney General's chambers.
It's still an office.
I am putting it to you that the letter was directly addressed to you to take action.
It was addressed to the Office of the Attorney General. In the absence of Attorney General, the Solicitor General minuted it to the DPP. That's not my signature, that's the Solicitor General's signature, which shows...
dañ ko bindoon ci office Attorney General bi ci dëddu teem nag Solicitor General bi moom moo ko lini ndax signé boobu nga gis foofu du suma sign.
Ms. Singhateh, this goes to show that directives were being sent to your office. Whilst you were the minister, and they were being implemented. It was your responsibility to supervise and look over everything that was done in that office whilst you were the minister.
May I say something?
You may.
So I said that it was signed by the Solicitor General, which shows how important it is to consult the Solicitor General when we're working on criminal cases, because in my absence, he acts on my behalf. So that signature on it is not mine, it's the Solicitor General's signature. And yes, I agree with you that the minister, when I was in office, I had oversight responsibility. But the minister is not God who can see everything and hear everything. That's why she or he has an able Solicitor General. And that's why, in my absence, the Solicitor General acts.
li mu bëgg a wax foofu na mooy comme ne lettre bi comme que Solicitor General moo ko signé loolu mooy wane njëriñ ak solo bi nga xam ne ni Solicitor General am na ko ci liggéey bi ba nga xam ne ni si dëddu teem Solicitor General mooy jël place am dal di def li nga xam ne loolu la waroon def.
Ms. Singhateh.
Yes.
In any event, such a letter should not be emanating from the President's office by the direction of the President to institute or direct the Attorney General as to what charges or how they should charge a person. So it is irrelevant as to who minuted the letter or who received and took action on the letter. The letter itself is improper.
Actually, the letter is fine. I say so because Section 76 of the Constitution vests the President with executive powers.
Just a
minute, here. Bishop, you want to raise a point of order?
Yes, indeed. I just want to say so. I want to believe that the matter in question is whether or not executive directives were received by the Minister of Justice and Attorney General. I think that's the thing that we need to have an answer, whether that executive directives used to come from the presidency to the Attorney General's chamber.
What's the point of order?
Yeah, because the fact is we are being drawn back to say that, well, it was the Solicitor General that, acted on behalf of the Attorney General, and it was the Solicitor General that signed, the executive order directing the DPP to take action. I think that's not the answer we're looking for. The question is, executive orders comes from the office of the President to the Attorney General and the Minister of Justice. And that is what we want to get clarification on, I think.
dafa am ay ndogal yoo xam ne daf daan bàyyeekoo ci président bi jëm nag ci office Attorney General bi pour moo xam ne noonu la bëggee mu doxalee.
I never denied that. I said, yes, we received letters from OP to the Ministry of Justice.
Mosuma weddi lool dama ne waaw deug la dañ daan joté lettre yo xamné ñu ngi joggé ko ci OP moy Office of the President mu ñew ci ñun.
And I even went further.
Dem continuer na sax di wax ne.
And I was actually going further.
Te ma ngi doon continuer di wax ne.
That section 76 of the Constitution.
Ni xatam juroom ñaar fukk ak juroom benn ci loi République bu Gambia fi.
Vests the president with executive powers.
Dal dina dolel president bi.
With executive powers.
Ak dole jo xamne ni mu aju ci wali togayam ci sam di president bi.
So if he chooses to send executive directives or letters to the ministry or any other ministry, it's his prerogative.
Kon nak bu fekke ne ina dal di bind ab letter ndigal bo xamne mu ngi joge ko ci mom ñew ci Ministry of Justice. Kon nak dafa dess ci mom rek ci xelam.
Ms. Singhateh.
Council, you may proceed, please.
Sorry, I forgot it was Bishop that asked the question.
Yeah.
But it is a follow-up to my question, and I differ with your answer. The president does not have the right to give an executive directive on matters of prosecution.
Bagna sa tontu bobu president bi amu doole bo xamne mom la ko palaasam bi jox pour muy jox ndigal ci lu aju ci ay atté.
But then it worries me now that this was the belief. Because then it goes to prove, to show why there were so many people who were recommended for prosecution by an executive directive from the president, and they were implemented.
That's not true. The reason why I say so, every case that is prosecuted for a reason and in accordance to law. Every letter that comes as an executive directive has a context. So that means the letter should not be seen in isolation. It referred to a letter that was sent to that office. Perhaps council would like to share that letter that was referred to in the executive directive. I also want to add that the president is vested with powers to address issues of national concern.
President bi rang nañ ko ak doole pour nak mu garal mbir mo xamne ni depo nak wali rew mi.
Be it economic interest,
mo xam muy ajo ci wali kom-kom,
security interest,
wala ci wali karange,
or public interest.
Wala li nga xamne moy jëri nit ñi.
So everything has to be seen in context of that executive directive.
Kon nak bor bu ne rek war nañ ko sété ci li nga xamne ni ëmb na ko nak di ndigal bobu joggé ko ci mom.
And to go further, my role as Attorney General,
te continuer di dem li nga xamne ni mo nekkon sumay satane Attorney General,
as principal legal advisor,
ki nga xamne ni may aju ci cadre yelef ci réew mi,
is to provide advice
moy pour dal di yedd
to the government,
ci nguur gi,
who is headed by the president,
jité ko nak di president bi,
and the cabinet.
ak itamen li di penchu ministre yi.
So where executive directives are not in accordance to law,
fo xamné ni nak ndigal li president bi depout ak yoon,
there's an opinion that goes to explain why they are not in accordance to law.
Am na itamen bunta bo xamné ni moy yaatal xelaat li tax nga xamné ni depout ak yoon.
And if you go through the files,
bo sété nak file bobu,
you will see my opinions there are plenty.
Da nga gis nak li nga xamné moy suma xelaat bari nañ.
And I know
te xam naa ne
when it comes to writing,
bu ñëwee ci binda,
no one writes better than me.
Amu kenn kuy mëna binda comme lu ma weesu man.
Or as much as I do.
Wala loo xam ne ni def na comme man ni ma dee binde.
I had files in that ministry.
Am na ay files ci ministry bobu,
ranging from OP to executive directive to judiciary to every department. Anytime that requires my opinion to be written, I write it.
Di ndigal mo xam nak ndigal yo xam joge ko na ci president dem ci judiciary wala ci yeneen bunta say bo xam ne ni aajo nañ suma xelaat rek dana ko fa bind.
That is my mandate and my responsibility.
Lolu moy suma mandat ak lolu suma warugal.
Whether they are accepted
waaye benn moo xam nangu nañ ko.
Whether the advices are accepted,
boo xam nag ndax li may yedde yooyu noonu ndax nangu nañ ko.
that's not within my control.
loolu nekkul ci loo xam ne ni saytu naa ko.
That's within the prerogative of the ministry responsible, or the ministry it was addressed to, or the office of the president it was addressed to.
loolu nag mu ngi des rek ci xalaati ministre bi nga xam ne ni fa la jëm wala ci office président bi mu jëm.
And that's the fact, and as lawyers we all know this. We act on instructions, we give advice, we have no control whether the clients accept the advice or not.
te lii mooy dëgg ne comme ñun ay lawyer lañ dañuy dox ci ay ndigal moo xam nag client bi nangu na liñ ko yedd wala déedéet.
Ms. Singhateh, you're taking this way out of context. Yaya Jammeh was not your client. He was the president. And he should have done things by the law. It is not good procedure. It is against the law for the president to target people and base it on executive powers for them to be tried, convicted. We cannot accept that.
May I respond?
It wasn't a response, it was a statement.
But I need to clarify the fact that I never said that I was President Jammeh's lawyer. I said I was a lawyer for government, and President Jammeh is the head of government. So government is an entity, and there has to be a head and a focal person. And I dealt with the Solicitor Secretary General, and the Secretary General related my messages and in my opinions to the president. So I'm not the president's lawyer, but I am the lawyer for the government who is headed by the president in accordance with the Constitution of the Gambia.
mu ne mu ngi leeral rek ne moom nekkutoon lawyer yi président bi waaye nag nekkoon na lawyer yi réew mi. nguur gi.
Président bi mooy head of nguur bi.
te président bi nag moom moo jiite nguur gi.
Pardon my
We're not, it's okay. If you want to clarify the interpretation, there's no problem with that. We're okay with that statement, but you went further on to say that the relationship between a client and a lawyer. Even with clients and lawyers, I think lawyers do not act on illegal instructions. So as lawyers, we really have to avert our minds to that. So the president did not have any right over any other citizen to send directives for persons to be prosecuted and eventually convicted and sentenced.
Just to also clarify, I never took any illegal instructions.
Every action
I took was done in accordance with the laws of the Gambia. So long as it's in the law books, it's the valid law. Let it repeal or declared unconstitutional.
We will get to that point, Ms. Singhateh. Don't worry, we will get there.
Please allow him to translate as well, please. Please, Mr. Translator, please translate that.
Well, let me take you straight on then. You remember the case of Mr. Usainu Dabo?
Yes.
Can you tell us about that matter?
I cannot at the top of my head.
He was arrested, correct?
Yes.
With other persons who were also in his category, sort of elderly. Is that correct?
I cannot confirm or deny that. I don't know.
All right. Well, that is correct information. And this matter was in 2016. And you made certain statements on that matter. I believe the Bar Association had paid you a visit. when the matter
had
just started. Do you remember that conversation?
No, but I'm sure you'll remind me.
They had indicated that there's no need for excessive force or for the detention of the persons who were arrested with Mr. Dabo, because they were elderly in some form and that they should be released. Do you remember that conversation?
No, but I'm sure you would elaborate.
Okay. I believe you stated that the act they committed was against the laws of the Gambia. Is that correct?
No.
I don't recall, but if that's what it says, then it must be, because the act they committed was definitely against the law of the Gambia.
At that point, though, one day entitled to bail.
Of course. Wow. It's a bailable offense, is it not?
Isn't it also correct that you received executive directives from President Yaya Jammeh then to prosecute and pay special attention to this matter?
I
don't recall that one.
Wasn't it also correct that there was interference with the judiciary to ensure that they did not grant them bail?
That's not within my knowledge, because I know I did not interfere with the judiciary to deny them bail. Everybody is entitled to bail if the offense is bailable.
Isn't it also correct that you advised the DPP to oppose bail?
No, that's not true.
Okay. Well, that is the information we have.
That's a false information.
And in any event, the DPP did oppose bail, even though it was a bailable offense. Isn't that correct?
I am not aware of that.
Okay. Being the overall seer of that office, you should have been aware of that matter.
I am not in court with DPP. I am not in court with DPP.
You should have advised the DPP not to oppose the bail in that application.
Okay, perhaps what you need to understand. Once the opinions have been approved for prosecution, it remains within the purview of the DPP to exercise its discretion in the case. I did not and I have not micromanaged the DPP. If a matter is bailable, obviously anybody is entitled to bail. But I can tell you that I did not instruct DPP either way. And I am the one on the oath.
Ms. Singhateh, I am always on the oath. Let's not go.
I'm just saying, because it's my testimony, it's my evidence.
On that case, it was a high-profile case. The whole world knew about it, not only the country, the whole world knew about it. And it was a case that was under your ministry. Under your watch. It was being prosecuted. The whole world knew that Ousainou Darboe and others were denied bail, even though the matter was bailable. I believe as the advisor to government.
And
as the AG responsible for that ministry that was pursuing the matter, you should have advised the DPP to withdraw his opposition to the bail application. I will leave that to the Commission to analyze.
Go ahead, do that.
In the same vein, in that conversation with the Bar Association, when they had indicated that they would be issuing out a public statement, you still don't remember that conversation?
I do not. I'm surprised.
You had indicated that if the bar members go ahead, they would be arrested.
That is completely and utterly false.
And
it's outrageous. It's absurd. I don't have the power to arrest, and I would never. That's not even my language. And I would be happy to hear who said that. Since it's a false allegation against me.
Ms. Singhateh, at that time, you were really interested in getting Dabo and others convicted.
That is absolutely false. And for your information and for the information of the commissioners and members of the public, that case was prosecuted according to law. He was convicted according to law. That conviction was upheld by the Supreme Court of the Gambia according to law. So this issue of what I said or what I did not say is neither here or there. But I can say this for the record. I don't recall, and I do not believe I did, have that conversation with the Bar Association, much more threaten them with arrest. That's not within my purview, that's not in my nature, and I did not have the power to do that. And let it be on record as well.
Mom lolu fateleku lolu itamen du ci jikko ci kaddom pour moy wax façon wax yoyu mbir momu tefar la bo xamne ni até won nañ ko ci yoon daldi dogal ci yoon té itamen jaarale ko ni nga xamne dal non la ko yoon tédalé.
At that time, all you were looking at was to please Yaya Jammeh and get convictions.
My job is not to please the president. My job is to advise on the law. That is what I did.
And for the
record, the opinion to prosecute in that matter, the opinion was independently drafted by counsel in the DPP's office. And the counsel is alive and well. He can testify that nobody pressured him. And DPP approved the opinion. And the opinion was endorsed by the authority of the ministry. By the Solicitor General, to be precise. And I agree with his approval. Let that be for the record as well.
Ms. Singhateh, there was a system in place that was created by Yaya Jammeh and his people that worked with him. And this system involved institutions such as the NIA, police, etc. And further, it involved your office. In the latter years of this country where Yaya Jammeh ruled, we had the worst human rights record. that anybody could imagine. And this was under your watch as the Minister of Justice.
Let it be on record that I was not used by anybody. I cannot be used by anybody.
I
refer you to the matter of Samsudeen Conte. Do you remember that issue of his sacking?
I do not.
Well, it was brought to your attention by the executive. And they had indicated that it be facilitated that he be terminated because of a decision he had given of a no-case submission. And you facilitated that.
That cannot be true. I did not hire the magistrate you mentioned. Neither was he working under me. So I could not have facilitated that.
Ms. Singhateh, I see you want this commission to believe that there was a normal system of running your office and the government and other institutions.
Yes, it was normal. It was normal. Perhaps your own perception is abnormal, but the way I saw it during my time there, what is within my knowledge, it was a normal system done in accordance to law.
Doxil mi de jaadu woon na xëy yow sa gis-gisi bopp mooy nekk daal jaaduwutoon waaye nag man suma gis-gis mooy liggéey bi mu ngi doon dox ci anam gu wér ak ni nga xamee dëppoo na ak yoon.
The ministry was within my control.
Ministry bi ci suma ron la nekkoon.
And I can tell you that everything I did that was within my control was done according to law.
I have
no control over what anybody else does. I have control over what I do. And what I do is always in accordance with law.
Ms. Singhateh, I disagree with that. And I will draw the Commission's attention again to the issues of the executive directives that we had discussed earlier. Further, I would also want to draw the Commission's attention to the interference in the judiciary, etc., by your office.
I would like examples, please.
I already gave you some examples.
That's not an authoritative example because I did not have any interference with the judiciary. I had played no role in the work of the judiciary. That's not within my mandate. It's not within my purview.
To give you an example of another matter, do you remember the case of the state versus Ansumana Jammeh, etc.?
Can you elaborate?
He was arraigned before the court, and a bail sum of $100 million was granted by the court. Do you remember the action you took?
Remind me.
Isn't it correct that you personally spoke to President Yahya Jammeh to reduce the amount of the bail?
That is absurd. Why would I ask him to reduce the amount of the bail? He's not a judge.
That just goes back to show you that the president was involved in everything. And the way you describe the ministry and indicating that under the Constitution he had executive powers to direct. It tends to show that he received the wrong advice and which enabled him to interfere into matters that he shouldn't have.
That's
absolutely false.
Well, it is before this commission, and we know that Yaya Jammeh was involved in all sectors of the government, all sectors, including the Attorney General's chambers. And just to let you know that this matter also showed that at times you did personally get involved in judicial matters.
What matter are you referring to?
The Ansumana Jammeh.
I do not agree with you. Can you elaborate? Because I don't know what you're talking about.
I finished on that point.
No, the allegations are false. Seriously, you can't just be making conclusions without even giving explanation for your conclusions.
The commission will decide on the issues.
But I can state for the record, I do not interfere in the activities of the judiciary. I have great respect for the judiciary because I used to be one of them. The way I did not want to be treated, I would never treat my colleagues that way. And let that be for the record as well.
Is it correct that you were the minister on the 8th of May, 2014?
My mandate expired in August in 2014.
So you were the minister at that time?
So it goes to show that I was the minister at that time.
Do you remember giving an interview to New Africa magazine? About the Universal Periodic Review Report to the UN Human Rights Council.
Vaguely.
Can you tell us what you remember?
I remember meeting with the lady from New Africa, the New Africa paper or New Africa report.
Is it correct to say that you were happy to meet with her and tell her that you were eager to attend the meeting and submit the report?
The Universal Periodic Report?
Yes.
Yes. I don't recall, but sounds right.
And you further went on to say to her that when it comes to human rights, we promote and protect the rights of everybody.
Sounds right.
And this was in 2014?
2014.
If you say so.
At this time, we know that Gambia's record on human rights was poorly. You further went on to say in your interview, the message is that we support human rights, we promote and protect everybody's rights, but unfortunately, what we hear about in the press in the rights is of those who committed offenses.
lañ dégg ci li nga xam ne moo di mbiri yelleef yi day mu ngi aju ci ñi nga xam ne ñoo di def ay tafaar.
The criminals who committed murder.
ñi nga xam ne ñooy ay tafaarkat yoo xam ne dañ rey nit.
When we punish them, all we hear about is those people who are fighting for their rights of the murderers.
su leen yoon di daan nag liñ ci dee faral di dégg rek mooy ñi nga xam ne ñu ngi doon doxal li seen yelleef ci kaw ñi reykat yooyu.
What about the rights of the victims?
léegi nag ki ñu rey nag yelleefam nag.
Is this the message you took to the UN?
ndax yow xibaar boobu moom nga yóbbu ci mbootaay bi.
I did not attend the UN UPR.
man teewuma woon ci jotaay boobu de.
But that's what I believe.
waaye nag loolu laa yaakaar.
As a prosecutor, I used to be a prosecutor.
ndax ni ki kuy dox ci wàlli atte dama daan dox ci loolu.
And we used to prosecute murder suspects.
te dañ daan atte nag ñoo xam ne dañ leen njort ne dañ rey.
We used to see the deceased and the family, the deceased's family, as victims of the violation of their rights, the family members' rights to life.
te tamit gis nañ ne tamit ñi nga xam ne ni ñooy ñi ci loru seen njaboot ñoom tamit nekk na ñoo xam ne xët nañ seen yelleef ci wàlli dund.
When we do prosecute those cases,
at this time,
that was the context that was the context. And because in this day and age, when you apprehend and prosecute a person, the only thing you hear about is the violation of the rights of the person being prosecuted. But we always need to remember there's always a victim behind the prosecution of the person, the alleged perpetrator. And that's what we must remember.
ndax jamono boobu liñ daan def mooy suñ jàppee nit koo xam ne dañ ko tuumaal ne dafa rey nit. liñ daan génn dégg rek mooy yelleef yi kiñ tuumaal ne dafa rey naka nag yelleef yi ki nga xam ne moom dañ ko rey.
And let me also say for the record.
te xaaral ma wax rek ci leeral.
I'm not denying that Gambia had human rights issues.
weddiwuma ne Gambia am nañ lu jëm si wàlli yëfi yelleefi doomu aadama.
I would be pretending or I would be fooling myself if I thought that we had a perfect human rights record.
bu fekkee nag ne maa ngi damay nax suma bopp bu fekkee ne yaakaar naa ne ñun wér nañ ci mbiri yàqat yelleefi doomu aadama.
But no country in this world has a perfect human rights record.
waaye nag amul benn réew boo xam ne mu ngi nekkee ci àdduna bii boo xam ne ni nag wér na ci wàlli yelleefi doomu aadama.
Mr. Singhateh, we're talking about the Gambia.
No, please, let me finish. We have an obligation as government officials to continue to do better and advocate for better, and I did that. ñun dañ am mandat ni ñuy liggéey ci nguur gi lañ pour def loo xam ne lu wér la te defoon naa ko.
I'm sorry.
In cabinet and in public.
ci cabinet bi ak ci biti.
And we used to have a political dialogue with the EU.
dañ daan am jotaay politique ak EU bi bootaay tugal gi.
Under the Cotonou Agreement.
ci nangatoo boo xam ñu ngi ko sësale woon sa Cotonou.
Where we will meet EU ambassadors twice every year.
foo xam ne danañ ñoo seq jotaay ak EU ambassadors yi ñaari yoon ci benn at mi.
And discuss about the human rights record of the Gambia.
ñuy waxtaanee nag lu aju ci wàlli xëti yelleefi doomu aadama yi fii ci réewi Gambia.
And I'm always the first to admit that yes, we can do and we should do better.
tey maa njëkk koo xam ne ni wax naa ne waaw war nañoo def tey tamit war nañoo def lu gën a yëwét.
But what I find very concerning is.
waaye nag li nga xam ne lu laa gis moo xam ne moo gën a soxa lu gën a soxo.
That foreigners would come and tell us about the human rights situation in the Gambia.
ne tamit ñi nga xam ne nii ñoo jógee ko bitim réew dañu ñëw fii di ñu wax li nga xam ne nii mu ngi jëm ci wàllu yelleefi doomu aadama yi ci réew mi.
When we had our own lawyers and so-called civil society organizations within the country.
te boobaa na fekk am nañ ay lawyer ak yeneen i mbootaay yoo xam ne ñu ngi dox ci suñ biir.
Who would stay mute and not say anything or draw any human rights violation to our attention.
yoo xam ne dañuy noppi teg duñ wax dara loo xam ne mu ngi jëm ci wàllu xëti yelleefi doomu aadama yëgal ñu ko.
Then go to the press and start crying foul for the violation of somebody's rights.
bu ko wee na ñu dem na ci bunti taseekaay xibaar yi di fa jéem a tawat di joytu ñi nga xam ne noonu lañ xëtee yelleefi ñenn ñi.
As the Minister of Justice.
ni ministre bi saytu wàlli loi ak àtte ci réew mi.
Most of the so-called violation that occurred was never within my knowledge.
lu bëri nag ci xëti yelleefi doomu aadama yi nga xam ne am na fi nekkul loo xam ne yëg naa ko.
It would have been nice for these things to be brought to my attention.
dana doon rafet nag lool pour fekkee ne yow yëgaloon nañ ma ko.
By my colleagues and so-called human rights defenders.
di sumay nawle ak ñeneen ñi nga xam ne nii ñoom seen liñ daan dox mooy baddu ak doomu aadama.
If they did not see it fit to petition the Minister of Justice.
bu fekkee ne gis ne daal doy pour nag ñu tawate ko ci Minister of Justice.
They could have walked into my office because I had an open door policy.
mënoon nañoo ñëw suma office ndax man nag nekkoon naa koo xam ne dama daan dox ci sax tay yaatal ñëpp.
The same way they used to come to my office to ask me to assist them with cases that they had.
niñ daan ñëwee suma office di sàkku ndimbal ci yenn tefaar yi ñu amee.
where their clients were in a difficulty.
ci foo xam ne seen clients yi ñu ngi woon ci ab jafe-jafe.
where their clients were paying them a lot of money.
foo xam ne seen clients ñu ngi leen doon fay xaalis bu bari.
walk into my office to plead on their behalf.
ñu ñëw nag suma office pour nag dal di ñaan ci seen tur.
That's the same way I believe they should have walked into my office to talk about the human rights violation or alleged human rights violation that they saw, they observed, or they heard.
te yaakaar naa ne ci anam googu nag lañ waroon a ñëwee suma office pour tawat yenn xëtti yelleefi doomu aadama yiñ dégg wala yiñ gis.
So that I would fulfill my mandate as Attorney General to provide the relevant advice to the necessary department concerned.
bu boobaa nag danaa mën a mottali suma mandat ci li nga xam ne nii mu ngi aju ci suma liggéey ne man maay ministre bi saytu wàlli loi ak àtte ci réew mi.
So I find it very rich that I'm seated here.
waaye nag gis naa itamit comme ni nga xam ne noonu laa toogee fii.
That I'm being accused of being an enabler or being part to whatever that was going wrong.
Ms. Singhateh, I don't think anyone said you were an enabler
when this was never brought to my attention.
ne ñu ngi may tuumaal ne bokk naa ci ñi nga xam ne ñoo maa daan dimbale ci loo xam ne ay ñaawteef la.
So this is a truth commission. Let's talk the truth.
lii nag pencam dëgg la nañ wax dëgg kon.
Are you done?
Oh yes, for now.
Thank you. I thought I should be leading the questions, but it seems to have turned. For a minute there, I thought it was Yaya Jammeh who was actually talking to us. Talking about why do the foreigners or the non-Gambians, etc., come to tell us about our human rights record.
Ms.
Singhateh, our human rights record was bad. It was one of the worst. And you were aware. And as the minister, you should have advised against such activities of people being detained. When we say detained, people being picked up and taken directly to mile 2. People being beaten and tortured at NIA. You did not need anyone to come and tell you. You knew about them. And you should have done the right thing and taken action. Because as the AG, you are there for the people of the Gambia and not for the government. Going back to the article. When it was mentioned that the human rights of the Gambia was highly violated, they were talking about people who were unlawfully arrested, people who were detained at mile 2 without any court order or having been taken before a court of law, people who were disappeared, people who were unlawfully killed. And that should have shown in this report. And not to talk about actual criminals who have committed an offense and face the law. Moving on. You were part of a committee that was established that was responsible for prison conditions, etc. Is that correct?
No, it's not correct.
Were you part of a committee that looked at the issues of the prisons?
I don't recall. I don't think so.
Well, the information I have is you were a member of the prisons committee.
I am not. I was not.
Then I will leave it and move on from that. We move on to the Tax Commission of 2011. It is correct that a tax commission was set up to look into the evasion of taxes and corrupt practices. Is that correct? And you were heading that commission as the chairperson.
That is correct.
Can you enlighten this commission about the Commission for the Tax Evasion?
So a commission of inquiry was established in 2011.
Commission of inquiry di gestu nak ay nama ñu ko taxawalon ci atum 2011
via legal instruments
ci jaaré ko nak ci anam juntuwaay yo xamné depo nak yoon
contained in a legal notice that was gazetted
ci loi bo xamné ni nak daldi won nañu ko siiwal,
which I'm sure you're familiar with because that's the same way your commission was established.
Lo xamné ni nak yo xam nga tax du mel non la seen commission bi ñu tok tay non lañ ko taxawalé won.
So the commission was the full name of the commission. May I read it?
Li nga xamné mo doon tour wi nga xamné mom la mo doon commission bi.
Commission of Inquiry into Tax Evasion.
Moy nak commission bi nga xamné ni moy seet nak lu jëm ci walu njuyam nama.
And other corrupt practices.
Ak yeneen ni jëf yo xamné ni nak ak tapalé la ak jubadi.
Of accountants.
Lu jëm ci walu buntu compte yi.
Legal practitioners.
Ak ñi nga xamné ñoo yëngu ci walu loi.
Engineers.
Ak ñi yëngu ci walu machine li engineers yi.
Medical practitioners.
Ak ñi yëngu ci walu paj.
Companies.
Ak borom compagnie.
And private persons.
Ak ñi nga xamné dal ñoy doxal seen bop la ñoy dox.
And institutions required to pay tax to the Gambia Revenue Authority.
Ak tamit nak buntu liggéeykaay yi nga xamné ni ñoom sàkku nañ pour ñu fay nama ci buntu liggéeykaay bi saytu wàllu fayekum nama ci réew mi.
Ms. Singhateh, before you continue.
Yes.
Singhateh bala nga eggali.
You're correct that the commission was set up by an act.
Dëgg la commission bi moom ci loi lañ ko taxawaloon.
However,
waaye nag ba léegi.
It was known that the said commission was particularly set up to target lawyers, to target legal practitioners, to shut them up so that they don't say things against Yaya Jammeh.
As the chairperson of the commission then, I'm saying that was false.
That
was not what I read in the legal notice. That's not how I understood it. And that's not how I conducted the affairs of that commission.
Can you tell us how you conducted the affairs of that commission?
Let me start by talking about the jurisdiction we had as established under Section 200 of the Constitution, which establishes commissions of inquiry. 201 of the Constitution provides that the chairperson of the Commission of Inquiry shall be either a judge or qualified to be appointed a judge. To be qualified to be a judge, you have to have at least 5 years legal experience, post-call experience.
And
to have 5 years post-call experience, at least 5 years post-call experience, you need to be a legal practitioner having been called to the bar. And you cannot be over 75 years old. So at the time I was appointed,
ti jamono biñ may tànn nag.
I was a judge.
Judge laa woon àttekat laa woon.
I had over 5 years post-call experience.
te boobu tamit am naa lu dem ci juróomi ati jiitali liggéey boobu.
And I was not over 40 years old.
te time boobu aw ma saf ñeent fukki at ak lu teg.
Much more to say 70 years old.
bañ caay wax na lu dem ci juróom ñaar fukki at.
So when the commission was established,
ci jamono bi nga xamee nag penc moomu taxawal nañ ko.
I was informed by a letter.
yëgal na ma nag di ab letter.
From the Office of the Attorney General at the time.
mu jóge ko ci office Attorney General bi ci jamono boobu.
To inform me that I was appointed as chairperson of this newly established commission called the Tax Commission.
di ma woon nekk fal nañ ma pour ma jiite penc moom nga xam ne nii mooy penc mi gestu nag lu jëm ci wàllu naama yi niñ ko daan mbase.
2 other persons were appointed as commissioners.
am na yeneen ñaari nit ñoo xam ne tànn nañ leen ñoom ñu nekk ay commissioner.
One was an economist.
kenn nag nekk na koo xam ne ku màcc la ci wàlli koom-koom.
The other was an accountant, ACCA.
keneen ki nag nekkoon na koo xam ne nii ku màcc la tamit ci wàlli biral ay compte yi la di ci maqaamam ACCA.
And he was also an auditor as well on tax issues.
tey tamit nekk na koo xam ne nii seggkat la woon lu aju ci mbiri fa naama yi.
So the mandate of the commission
kon nag li nga xam ne moo nekkoon sa si commission boobu.
was to inquire into the incidents and dimension of tax evasion and avoidance.
mooy nag ñu xeñtu ci anam gi nga xam ne ni noonu lañ daan njuyee mbiri naama ak niñ ko daan moytoo ba duñ ko def.
Ascertain the extent of the loss of public revenue resulting from capital gains tax.
tey tamit nag loolu di feeñal ci tamit ndaanu te goo xam ne waroon nañ koo am ci mbiri koom-koom bokk na ci li nga xam ne loolu lañ daan am ci wàlli naama yi.
Personal income tax.
ak li nga xam ne nii mooy taxe bi nga xam ne nii kenn nit moo koy fay.
Sales tax.
ak wàlli naama ci wàlli njaay.
And determine the role of individuals.
ak tamit nag seet nag li nga xam ne moo nekk wàllu gari nit ñi.
Groups and professional bodies.
di mbootaay la ak ñeneen ñoo xam ne nii ñu màcc lañ.
In the evasion and avoidance of tax.
ci ni nga xam ne noonu la ñuy njuyee ak ni nga xam ne noonu la ñuy bañ a fay naama.
So in my view, when I read this mandate, this requirement of what was expected of the tax commission,
ci suma gis-gis nag jamono bi nga xamee ni jàng naa li nga xam ne ni loolu la aajoo loolu la lamboo di tax commission bi.
I understood it to mean
ma xam ne loolu moo ràññee ne.
an inquiry into everybody's role in the payment of tax.
di gestu nag ñëpp li nga xam ne mooy seen wàll ci wàlli payam naama.
Particularly professional bodies.
rawatina nag ci ñi kuréel yi nga xam ne ni nag lu kuréel yu màcc lañ.
Companies, private persons and institutions.
di compagnie ak yenn benn nit ñi ak tamit buntu liggéeykaay yi nga xam ne ñooy doxal seen bopp dépasse.
But to my mind, the rule was very broad. The mandate was very broad.
waaye nag gis nañ ne bu sas woon na lu yaatu la.
So let me just cut it short.
Let me ask questions to follow up on what you would want to say anyway. It was seen that there was a selection of persons who appeared before the commission. Is that correct?
No.
Did it?
If you read the report, you would see that there was a system that was in place.
That's what I was going to get at, Ms. Singhateh. That's why there were certain categories of people who were called before the commission. Not everybody was called. Isn't that correct?
The whole country was not called, true. But the fact that you say a category, especially when I've already listed out the list of people that were that were under the mandate of the tax commission, I couldn't understand why you said category.
How many lawyers were called before that commission?
Let me say this. When the tax commission started its work,
yes? Can you answer my question first?
The reason why I'm saying this, because we're treading on a very dangerous path here.
Well, this is the Truth Commission.
It's the Truth Commission, but it's also a commission. And I also headed a commission. So it's not fair, neither is it right, to inquire into the affairs of a commission that has already been concluded. When the man, yes, carry on with the interpretation.
Du jaadu nak pour ten tuite men li nga xamne mo nekkon doxalini commission bo xamne ni sotal na mandam.
When the mandate of the commission expired,
jamono bi nga xamé ni mandat am jeexna,
the commission prepared a report and submitted it to the executive.
Commission bi na bind nañ seen report àggale ko nak ci njiiti réew mi.
Through the Ministry of Justice that contacted them.
jaarale ko nak ci ministre bi saytuwaale loi ak àtte ci réew mi ñi nga xam ne ñoo leen ko joxoon.
The report consisted.
I would love you to answer my questions. If you cannot answer it, you indicate that you cannot answer the question.
I am answering your question. It's just that I'm not answering the way you want me to answer it.
My question was, how many lawyers were called to appear before that commission?
I cannot tell you at the top of my head. It's in the report. So perhaps you might guide me if you have the report before you.
How many business entities were called to appear before that commission?
It's in the report. I cannot tell you at the top of my head, but if you read the report, you would know.
Yeah. Mënuma ko fateleku ndax ci suma bop bu fekkee nak ne mu ngi ci report bi boko jangé dang ko xam.
But it is correct that there was a select of lawyers and also a select of companies that appeared before the commission.
And the reasons for that decision was also explained in that report.
I will get to that.
Okay.
If you stop being so defensive, you might get where I'm getting to.
No, I'm sorry if you think that I'm defensive.
Yes. Okay. What was the reasoning behind not all the lawyers being called to this commission?
Again, I cannot talk about the workings of the commission and the reasoning behind the commission.
Mënuma wax li nga xamné moy liggéey doxalini liggéey commission bobu ak li nga xamné mo doon waruga li taxone mu am.
Because not only are you creating a precedent,
nekku rek ne sa da nga nek di xalé nak luy jëm ci kaw.
It's not right.
Nekku nak lo xamné ni jaadu na.
Once the Commission of Inquiry completed its work,
gannaaw bo xamé ni jéxal nañ seen mandat ak seen liggéey,
its mandate had expired.
Mandat am jeexna.
There's no law that says that anybody should ask any commissioner or chairperson about the content of the report and require an explanation about the content of the report.
Amul ben nit ko xamné ni amna doole laaj ki nga xamné moko jité won wala kenn ci commissioner li nga xamné mom la report bobu ëmbon.
Because to ask about the activities of the report,
I will move so that we don't waste the time of the commission.
Okay, no, but since you're talking to the public, let's all talk to the public and the members of the commission. We need to understand why. Once the work of a commission is completed, and that includes this, your Truth Commission and every other commission, the mandate of the commissioners have expired. So it is not right for anybody to call up the commissioners again and ask them about the activities of a commission of inquiry, which has produced a report that is public, it's in public record.
I will move forward, but I differ with that. There is no problem in me asking who were the people called to appear before the commission.
There's no problem.
Public knowledge.
I agree with you, there's no problem, but it would lead to problems. So the better thing to do is to avoid it completely.
May we move on?
No problem, I agree.
You have already indicated that a report was done and submitted.
Yes.
When you finished your work at the commission, did you return back to be a judge?
Yes. Yes.
How long was that before you were appointed Attorney General?
I completed my work in March.
In
2012.
2012.
And I was appointed minister in August 2013.
And you def ma minister very August 2013.
So that was over a year.
Is it therefore correct to say that at the time you were at the ministry, the recommendations of that commission were being implemented?
Yes, they were being implemented before I even got to the ministry.
But you got to the ministry and the implementation was continuing.
I got into the ministry that the implementation was ongoing.
When you became minister, you now took over responsibility of all the files in the ministry.
I became responsible for all the files in the ministry, but I expressly requested and instructed the Solicitor General to take over all tax commission files.
dal di woon naa jël file yëpp nag ci ron ministre waaye nag dal di woon naa xentu li nga xam ne mu ngi jëm ci wàlli taxawaay Solicitor General bi lu jëm ci wàlli tax file boobu.
Because I felt that it was a conflict of interest and I did not want to deal with the tax commission anymore.
gis nañ ne tamit dama bañ rek ñu gisee ko rek ne daal am na yenn xaajaloo soxla yoo xam ne dal di sa dugg te buggee woon ko noonu.
Ms. Singhateh, is it also correct that almost everybody that appeared before that commission filed an appeal against the findings?
Ndax dëggal la ne ñi nga xam ne yëpp yóbbu woon nañ leen ci kanam commission boobu daal dinañ sàkku pour ñu dappelaat àtte boobu noonu.
And that is the way it's supposed to be. Everybody has a right to appeal to any adverse findings made against them.
And is it also correct that most of those appeals were upheld by the Court of Appeal to state that the findings were incorrect?
I cannot comment on that, but I know that there were a lot of consent terms agreements that were filed.
mënuma wax ci loolu bari de ndax waaye am na nag yu bari yoo xam ne mu ngi jëm ci file yooyu li nga xam ne loolu la ñu am.
And consent terms is the agreement between the Attorney General's office and the person against whom the adverse findings were made. So that means both agreed, and the court adopted that agreement as the judgment of the court.
di nangotoo yoo xam ne nii mu ngi dëppoo ak Attorney General bi ak ñi nga xam ne nii ñooñu fara seen mbir yooyu noonu ci lañ leen ko teg te court ba loola jël tey tamit mu doon dogal.
Ms. Singhateh, you see, if you listen to my questions, we'll agree. There were two sets. There was one where parties actually won the appeal, and the findings were set aside. And there was the other set where there were consent terms. And even considering the consent terms, the amounts were reduced in the fact that the findings were not correct.
If you say so.
Thank you. Mr. Chair, at this point, may we take the second break? And continue when we come back.
Thank you, Council, and thank you, Madam Singhateh. We will resume at 2:30 sharp. Meeting is adjourned.
Thank you. Thank you.